many more participants or several more participants in the coming days. So tickets on sale this afternoon. Okay, where does that take us then? We're just calling this legal manipulation, Charles.
We are, and it follows a segment that I did last week, which actually started on the subject of geoengineering, but it was really to plot the course between the idea that people hold views that are counter to the narrative, or indeed dissenting views, and how they may become entangled in a web laid by both legislation and the entirety of the criminal justice system. So really, just going through a couple of examples now to have a look at how the system is in effect loaded against the dissenting voice, whether it be a sincere dissenting voice or not. And for the first example, we do in fact go back to Tommy Robinson, Stephen Yaxley Lennon, because within the last week, he has been arrested in a very well publicized sense for what were called terror offences, or at least under terrorism legislation. And I just wanted to clarify the situation, because in actual fact, this was under the Terrorism Act 2000, but specifically under Schedule 7, which bears looking at in closer detail because of what it actually enables. Now, Schedule 7 provides police officers with unique powers to examine people who pass through the UK's borders. It allows them to stop, question, and when necessary, search and detain individuals and goods travelling through the UK's borders to determine whether they may be involved or concerned in the commission, preparation, or instigation of acts of terrorism. So as you can see from that first bit of text, it's quite wide open. It goes on to say the examination of an individual under Schedule 7 is not conditional upon having grounds to suspect that that person of being engaged in terrorism, but the decision must not be arbitrary. There are a range of safeguards and measures in place to ensure appropriate use of the powers. So quite clearly, it can be used as a fishing expedition because there doesn't need to be any evidential basis for detaining somebody under Schedule 7. And this is exactly what the Robinson situation brought out, because in actual fact, he was arrested for breach of an injunction on a totally separate and unrelated matter. And yet this was the power invoked. And of course, the message here is to be sending it across to people that anybody could, in effect, be ensnared by this. The next thing to look at is effectively a misrepresentation by him, whether intentionally or not, of his right to silence. He released a video after this in which he spoke about having been compelled by police to answer questions. Now, that is not actually the case. And we look at the rights under the Terrorism Act 2000 that you have whilst detained. Your right to remain silent if you are asked questions about your suspected involvement in the commission, preparation, or instigation of acts of terrorism, you do not have to say anything. However, it may harm your defence if you do not mention when questioned something which you later rely on in court. Anything you do say may be given in evidence, which in effect is the standard caution, just with a little bit of additional text for the Schedule 7 preparation and commission of acts of terrorism. So whilst clarifying that there is still the right to silence, what he, I think, was actually referring to is the compulsion under the Regulation of Investigatory Powers Act 2000, was the compulsion under Section 49 of a notice to disclose. And in effect, this means that if there's information that police say that they absolutely require, then you are compelled, effectively at pains of a criminal sanction, to give up that password or whatever it is to allow somebody to access the particular piece of information. So we'll just look at the Ripper Power Act of 2000, but within it here, the power to require disclosure. A disclosure requirement in respect of any protected information is necessary on grounds falling within this subsection if it is necessary in the interests of national security, for the purpose of preventing or detecting crime, or in the interests of the economic well-being of the United Kingdom. So again, it's perfectly easy to see that these criteria here are so wide open as to allow for what might be called a fishing expedition. And police in instances like this are supposed to be very particular as to what information they suspect may be there, and therefore what they will actually look at. But of course, this allows by manipulation of the system for police to not only look at something in the first place, perhaps on spurious grounds, but then to find things which they weren't actually looking for, but can then act upon. So this is a manipulation of the process, and indeed people should be very mindful of this. The other thing that we should look at now is the new government's adherence to the old government's pursuit of what's being called Martin's Law, which relates back to the Manchester Arena attack, or alleged attack, perhaps I should say, to strengthen the security of public events and venues. Now, that has a very familiar ring to it if you cast your mind back to the vaccine passport legislation of late 2021. But nonetheless, we will update the rules around counter-extremism, including online, to stop people being radicalised and drawn towards hateful ideologies. Labour will also ensure the police and intelligence services have the powers and resources they need to protect the British people from terrorism and hostile espionage. Now, there's no greater detail given on that, but one does wonder what exactly is meant by powers and resources needed. But having mentioned Manchester, it is also worth pointing to the case of Richard D. Hall, which has re-emerged effectively last week. So he's been back in court again. I've got on screen now the trial going back to February of this year in front of Master Davison. And there's been a lot of talk about this with regard to freedom of expression, but I should just remind people that in actual fact, the specifics of this case, which is a civil case, are set out quite clearly here, which was on the 17th of April 2023. The claimants commenced proceedings against the defendant for harassment, misuse of private information, and data protection breaches. Essentially, the claimants complain that in his book, in videos published on his website and on YouTube, and in public lectures, the defendant has accused them of lies and deception and has misused personal data, including their names, images, and medical information. Now, the reason to make this clear in the eyes of the court is, as I say, to demonstrate how the system is set up in order that Richard Hall's case, as I say, in the civil court, hangs on the balance of probability. And so, again, this is from the same document from what the judge has effectively summarised. And this was Hall's effort to put forward what he regarded as evidence of something having not happened. But the judgment was that the important and governing principle is whether there are reasonable grounds for believing that further evidence or investigation would affect the outcome of the case. And he says there are no such reasonable grounds. He goes on to say further evidence and investigation will increase the volume of material that a trial judge would have to consider and time required to do so. But it is clear that the material will not affect the outcome. So the reason for pointing that out is to say that because the threshold within a civil court is on the balance of probability, the judge was in effect able to say that Hall's evidence was inadmissible. It was pointless to look at it because on the balance of probability, the narrative version of events in that an explosion did occur and people were wounded in the way that they described themselves as being wounded is on the balance of probability the case. So to clear that obstacle, with that being the case, is an absolutely monumental task, which explains the predicament to a certain extent of Richard Hall. Now, what I also want to go on and deal with, because since we're talking about terror, and we introduced the idea last week of government, in fact, being the genesis of the word or the description of terrorism in that it was acts by government. We've seen this many times before. We go back to 23rd of March 2020, where the Behavioural Insights team offered advice to SAGE, and we see here the perceived threat with regard to COVID. A substantial number of people still do not feel personally threatened. The perceived level of personal threat needs to be increased among those who are complacent, using hard-hitting emotional messaging. And I'd like to set that within the context of the Terrorism Act 2000, and in particular the definition of terrorism, which specifically says that terrorism means the use or threat of action where the use or threat is designed to intimidate the public or a section of the public, and the use of the threat is made for the purpose of advancing a political, religious, or ideological cause. So rather than get caught up in exactly what the government is suggesting may be qualified as a terrorist attack or terrorist activity. We should really be looking at the government itself and the way in which it's dealing with its citizens.
Charles, thank you very much for that. And